Hi again. So still doing a series on the eunuch, natural eunuchs. In ancient Rome and the Talmudic definition of natural eunuchs. This is kind of long, so it might be a two-parter as well. So forgive me, but I really wanted you guys to get all of this. All right, so the natural eunuch in Roman law, not deceased or defective. Okay? When the Roman jurist Ulpian states in Lex Julia et Papia, Book 1, Digest 5060, 128, that the eunuch is a general designation. The term includes those who are eunuchs by nature, moreover, the crushed and the pounded, as well as any other kind of eunuch. He places the natural eunuch first. Mutilated eunuchs are placed into a secondary rank after an accentuating Latin conjunction item, which I have translated as moreover. Unfortunately, Roman law does not provide a statement of what exactly unites the various types of eunuchs under one general classification, but it does provide more material for understanding the distinction between types of eunuchs. The law says that someone who cannot easily procreate is nonetheless entitled to institute a posthumous heir, but it gives no concrete examples of such a man. In the same context, it states that the eunuch holds this right as well, while castrated men expressly do not. Elsewhere, the Ulpian discusses whether money given in lieu of a dowry when slaves enter into a marriage-like partnership is to be counted as an actual dowry after the partners have become free. In this context, the Ulpian mentions a special case. When a woman marries a eunuch, he says, I think that a distinction must be drawn as to whether he was castrated or not, so that if he has been castrated, you may say that no dowry can exist, but a dowry exists, and the claim for the dowry against the one who has not been castrated because a marriage exists. The distinction that Ulpian is making here is between the non-castrated eunuch who is eligible for marriage and a castrated eunuch who is not. Note first that the the term eunuch can imply a castrated or a non-castrated man, and second, the qualities of the two types of eunuchs are significantly different. I apologize to my male friends here that this castrated stuff must make you just go, ooh. So, sorry about that. Okay, so, what is a non-castrated eunuch? He could be a man who is missing testicles by some process other than castration, such as the aforementioned crushing or pounding, or by a trophy due to illness, or one who was simply born without testicles. Such a eunuch would be, technically speaking, not castrated. Walter Stevenson had speculated that the crushing and the pressing were procedures some now not associated with the more drastic castration. Perhaps it is the process of cutting that disqualifies the castrated man for marriage. In fact, another part of the digest, Ulpian, once again singles out the castration as a negative. Ulpian notes, the Emperor Hadrian made the manufacture of eunuchs specified as castration, subject to the same penalty as murder. However, we see that Paulus filled in Ulpian's omission of other types of mutilation when he recalled D 48.8.5 that those who make, Thilbius, who crushes the testicles of others, are in the same position as those who do castrations. The suggestion that crushing and pounding are like castration before the law. Well, I would think so, my God. Okay, so it is the destruction of a man's body integrity that is the issue? By this logic, the mutilated eunuch would be unable to marry because his bodily integrity, and with that, his dignity, had been compromised. while natural eunuch is born incapacitated and his integrity has not been injured by himself or somebody else. As plausible as this late hypothesis might sound in the Roman context, another distinction is actually at work here, as we shall see. That there was some kind of lemon law for slaves of the Roman Empire, just as modern times used car dealers may be prohibited from concealing major flaws in cars. Roman slave dealers were prohibited from concealing serious flaws in slaves that they offered for sale. The purpose of the ruling in Book 21, Title 1 of the Digest was to determine what kinds of flaws would give rise to the rescission of a purchase contract if the seller had not reported them before the sale. So minor flaws such as a long ago healed wounds or stuttering speech, were called defects and did not require disclosure. Relevant flaws such as blindness or tuberculosis were called diseases. The jurist Sabinus defined disease in this context as an unnatural physical condition whereby the usefulness of the body is impaired for the purposes for which nature endowed us with bodily health. Eupion declares that if there be any defect or disease which impairs the usefulness and serviceability of the slave, that is a ground for recession. We must, however, bear in mind that a very minor flaw will not lead to this being held defective or diseased. Thus, a slight fever or an old recurrent fever can now be ignored, or a trivial wound would entail no liability if it be not declared. Such things can be treated as beneath notice. Thank goodness we don't have that anymore today. Anyway, so Vivian says that we should still regard as healthy those with minor mental defects. Otherwise, the health of a slave could be defined without limit, for instance, because he is frivolous and superstitious or quick-tempered or obstinate or some other flaw of mind. Eupion ultimately stipulates that generally the rule which we appear to observe is that expression of defect and disease applies only to the body. All in all, if the defect be one of the mind alone, there will be no recession unless the vendor had stated that such defect does not exist when in fact it does. If the defect is wholly physical or a combination of the physical, non-physical, there is a scope for recession. Plautus says, D21:1-5, just as there is a distinction between those defects which the Greeks describe as a malignancy and those categorized as misfortunes, maladies, weaknesses, there is a distinction between such lesser defects and that the form of disease whereby the usability of a slave is reduced. So we see the principle is that the slave is diseased for the purpose of the law if he has a bodily flaw which diminishes his usability, which for a slave means his ability to perform certain functions that may be of value to his owner. Now we come to the point that interests us today. The law finds that eunuchs did not have an incapacitating bodily flaw. Okay. So Eupion says, to me it appears the better view that a eunuch is not diseased or defective, but healthy, just like a man who has one testicle, who is also able to procreate. Therefore, Eupion is saying that the usefulness or the capability of a eunuch is not destroyed by his being a eunuch. He is able to procreate. How can this be, we ask today? Eunuchs, as we know, are made unable to procreate by their emasculation. Paulus clarifies, if, on the other hand, someone is a eunuch in such a way that is missing a necessary part of his body, even internally, then he is diseased. So the reproductive ability of the unqualified form of eunuch is not destroyed because he's not missing any necessary parts of his body. If it were impossible for a eunuch to produce a child because of bodily characteristic, even a naturally occurring one like an anatomical birth defect, then that would clearly constitute a disease under this section. But Upayan says a eunuch is not diseased, but healthy. Apparently, eunuch's status must be an issue of mind, featuring no disabling anatomical defect and therefore having no legally relevant consequences. By the way, I have never seen this section of the digest cited in any article or book about eunuchs. I found it by looking up spado in a concordance to the Corpus Juris Civilis. To recap, the distinction for Upayan and Paulius is between a eunuch whose capability to procreate is destroyed because his missing necessarily parts of his body, and an anatomically whole eunuch for whom procreation may be psychologically difficult but is biologically unimpeded. So returning to Upayan's other statements about the various types of eunuchs, we recall eunuchs by nature, crushed and pounded eunuchs, and castrated eunuchs. Out of these categories, the crushed, pounded, castrated lack necessary parts of their body and are physically incapable of procreation. There is only one category left for anatomically whole eunuchs. They are natural eunuchs. And so it goes on, okay. So what of the defined natural eunuch if he is anatomically intact? For that we must consider ancient notions of how reproduction occurred. Ancient doctors had no knowledge of sperm cells and egg cells, okay? The cause of the conception was thought to be a dynamic heat found in males which can transform already existing non-generative fluids into a formed generative state, much like egg whites gel and whitened in soft-boiled eggs. When implanted in the womb, this seed would be nourished and grow into a baby. According to a long-standing tradition dating at least from Aristotle, women's fluids were generative because it was thought that their bodies were too cold and moist to give form to semen. Generations of Animals 124 and 1, and this was why women could not produce children without males. To produce a child, semen first had to be poached, as it were, by the heat of the male's orgasm. Eunuchs were considered like women, that is, cold. Therefore, their fluid would normally be watery and sterile too. Applying Aristotle's reasoning that the concoction of semen by heat makes it generative, I surmise that the eunuchs were deemed unable to procreate insofar as they didn't feel the heat of the passion during procreative acts with women. It is only if a eunuch can penetrate and reach passionate orgasm with a woman, not an easy thing for him to accomplish, and he can also implant concocted semen in her and procreate like a male. But then he would also cease to be considered a eunuch, having in his way proven his manhood. Okay, so in a 2nd century, eunuch would simply be a homosexual who was impotent with women. Durr. By the 9th century, the meaning of eunuch had shifted and narrowed. Byzantine Emperor Leo VI no longer had to distinguish between types of eunuchs. For example, without noting that he was changing prior law, Leo absolutely prohibited eunuchs from marriage. Only castrated men had been prohibited by the ancients, not eunuchs in general. Constitution 98. On the other hand, in spite of the fact the eunuchs were allowed to adopt in all earlier laws, Leo presented this law permitting eunuchs to adopt as a change. Constitution 26-27. And it was a change because by eunuchs he meant only mutilated men. He felt that the ancients were wrong to prohibit adoption by men who had suffered lethal acts. According to Leo, the ancients stated as a reason for this exclusion was the law should not recognize persons from nature, does not consider qualified for generation as suitable for this function. But Leo corrected the ancients by then and anachronistic view, for it was not nature but human beings who had injured them, and we do not think